lost. And I think if we were to approach the law thinking that one case can change the world, then you need to revise your thinking on it. The law, unfortunately, is far too conservative for that. It has a role to play. It has a very important role to play. We have a role to play in supporting those who are fighting for social justice. But the case is not really about the law or about the lawyers who are seen in the courtroom bringing the cases. It's about what's happening behind the lawyers who are bringing the cases. The Counsel case is still important despite not having achieved what it ultimately, ought to have achieved. We do know, at least, that there was a change in the approach to the budget in housing, because what the court emphasized was the importance of protecting those in desperate need. And that was a pretty strict standard. And it's been a standard that we've used since then, to bring other cases to the court regarding temporary shelter, including in relation to evictions. As you know, SERI has done remarkable work on this. So what the government has had to do is have something in the budget that's called a Counsel allocation in order to ensure that there's some resources available to deal with those in desperate need. So there's a move forward, there's a step forward in some respect. It's not a total loss, and you shouldn't see it that way. There's a step forward in the jurisprudence. This is debated amongst academics, whether the court was right in the way it developed its paradigm of reasonableness, or whether it should have been a minimum core obligation that was recognized, which we now know, that's not going to happen. That's an academic debate, but it doesn't matter, because that judgment actually laid the foundation for future cases. So this was positive. Didn't change things for Ms. Counsel, and it didn't change things, sadly, for a number of people. But for some, it did. Then we have the Treatment Action Campaign case. This case was a case that it's become sort of emblematic of what good social justice, what sort of effective social justice litigation should look like. Why? Because it was led by a social movement. It was led by the Treatment Action Campaign. It was one case amongst many, by the way. It's called the TAC case, but there are many TAC cases. This is the case, as you know, that fought for the right of pregnant women living with HIV to have access to an essential medicine called nevirapine in order to prevent the transmission of HIV from mother to child. The government at the time, in all its wisdom, refused to make this available in the public sector. The Treatment Action Campaign, through huge mobilization in the communities and a women-led movement, by the way. The Treatment Action Campaign was, the General Secretary was Zaki Ahmed, a brilliant and absolutely insightful strategist who was at the helm in some ways, but actually the driving force behind the Treatment Action Campaign were women. And the mobilization in the communities is what led to this case ultimately getting into the court. The Treatment Action Campaign wasn't a movement that began as antagonistic to government. It began as a movement, in fact, that was trying to take on Big Pharma in order to reduce the price of antiretrovirals so that it could be affordable for the state, so that it could be affordable for women who bore the brunt of the epidemic and who were unable to access that medicine because they relied on the public sector, because these are women without the resources to have medical aid and get in the private sector. So that's how the treatment action campaign started. History is there for you to read. It had to challenge government in order to get access to the medicine, and it ended up in the Constitutional Court. Now, the difference between this case and the Grootboom case is that at the time when the treatment action campaign case was brought, there were very few women, a handful of women, who were receiving this medicine in the public sector. And why were they receiving it? Because they were part of trials. So in certain trial sites, they had access. So it was virtually nil, right, who were receiving it. Fast forward to where we are now, and we have more than 5 million, in fact, close to 6 million people, not women, all adults, on antiretroviral treatment. This is a case in which you can actually measure the impact it's had. If you just measure one aspect of it, and that is access to medicines. It was a phenomenal achievement. It required the treatment action campaign subsequent to this judgment, by the way, and this is what was important, and that's why I'm talking about this movement behind the case. The implementation depended on the movement, because the government did not implement the judgment immediately. There had to be a threat of a contempt of court application in order to ensure the implementation, and there had to be constant vigilance. So this was a case, in many respects, that is emblematic of the best of social justice litigation. And then I want to take another case, and this now, so there's housing, there's health, and then there is land rights. And again, here, there's a lot to say about it. These cases and these issues are all very complex and too complex for the amount of time we have here. But I want to talk about the land access movement of South Africa case. This case, and this is where the late Constance Bogale comes in. This case was a case that was brought against the government regarding the Restitution of Land Rights Act, which, as you know, was an important act meant to redress dispossession, those who were dispossessed of land. And there were land claims that needed to be lodged, and there was a cutoff date of 1998. That time had passed. Most of the claims that had, first of all, not enough claims were lodged by that date. Second, of those claims that had been lodged, a bare trickle of them had actually received any attention by the authorities. So there was a challenge to the amendment to the Act, which was going to extend the cutoff date. What I want to say to you is, first of all, it was a case that was brought by a movement. And like the treatment action campaign case, it was led by a woman. And what Madlanga J said, and that was in 2016, what Justice Madlanga said in the first paragraph of that judgment, if I may read it to you, is the following. This matter concerns the painful, emotive subject of colonial and apartheid-era land dispossession, a subject that, despite the democratic government's effort at resolution through the Restitution of Land Rights Act, continues to plague South Africa's politico-legal landscape. To those who personally experienced the forced removals and those who, instead of inheriting the illegitimately wrestled land, inherited the pain of loss of homes or property. The dispossessions are not merely colonial and apartheid-era memories. They continue to be post-apartheid realities. So he began his judgment with a reminder to all that this is not history that we're dealing with. This is now. What happened then affects us all now. And two, that there needs to be an urgency in dealing with it. So they declared, you know the case, it was declared invalid for a number of reasons, most importantly because of lack of adequate public participation in the process of developing the Amendment Act. And the Speaker of the National Assembly was given 24 months to correct the law and to have a proper public participation process in the development of the law, to enact the law, and to begin addressing the backlog in land claims. What happened? 2 years later, in fact, after that 24-month period had expired, the Speaker approaches the court to ask for an extension of time. So the question here is, where is the urgency in government to address this? And why is it requiring an organization like the Land Access Movement to be so vigilant that they have to hold the government to account to say, you've actually got to do something here? So the Speaker goes back to the court and says, after the deadline, to say, we need more time. Frankly, it was an outrageous development in that case, and that 2 years later, essentially, nothing had happened. So they go back to case. Land Access Movement is represented in that case, obviously. They oppose the request and ask the court to make an order itself, basically write the law, because you can't rely on this lot to write the law, which is what the court did. And in that case, so the second time around, and that was 3 years later when the judgment effectively was delivered, it was a judgment that was written by Justice Mklantla, and she too began by reminding all of us that there can be no freedom without land. That was the first sentence of her judgment. There are other cases related to land that are enough to make your blood boil, like the Mwelasi case. So we have Land Access Movement, beginning, they go to court, nothing happens by government, but by the legislature, which is the source of the delay. They go back again. Then comes the Mwelase case, and this is a case that was related to the Labour Tenants Act and the backlog in claims brought by Labour tenants. And this was also in 2019. And it was a shocking example of the failure, not of the Parliament by this time, but by the executive, to ensure that land claims were being processed timeously or at all. That judgment was written by Justice Cameron, and opening paragraph of his judgment reads as follows. Earlier this year, in a case about Parliament's constitutional duties, this court stressed that land and dignity were fundamental to realizing other constitutional rights. Land reform should be a catalyst for structural change in our society, the judgment noted. And there he was referring to Justice Madlanga's judgment. But delays in processing land claims have debilitated land reform. He quotes again, pardon me, from the earlier judgment, and then he says, each of these, pardon me, each of these urgent words are opposite to this case.
All right, Advocate Adila Hassim SC there, delivering a keynote address, basically speaking about activism law and how the law has managed to be applied to ensure that there has been justice in a number of instances that she's given there, going as far back as you would recall, of course, when there had been litigation regarding the access of South Africans to antiretroviral treatment. You'd recall the Treatment Action Campaign had been at the forefront of that. And as a result of activism through law, we saw many South Africans, in fact millions, then get access to antiretrovirals. So essentially the discussion taking place there at the SWCM Law Colloquium is about activism through law and how that can change the circumstances of ordinary people.